Good morning, ladies and gentlemen. Welcome to the thematic discussion on the review of local government's implementation of personal data protection on government-citizen interactions interfaces, jointly conducted by the Institute for Policy Studies and Communication Development and the United Nations Development Programme in Vietnam, with the support from the Australian Department of Foreign Affairs and Trade and the Irish Embassy. Attending our discussion today, may I have an honor to introduce Mr. Nguyễn Trọng Khánh, Head of Division of Infrastructure and Digital Data, the MIC, Mr. Nguyễn Dương Anh, Vice Director of Thừa Thiên Huế Center for Information and Technology, Mr. Nguyễn Lâm Thanh, Vice Chairman of Vietnam Digital Communication Association, Mr. Patrick Hefman, Deputy Resident Representative of United Nations Development Programme in Vietnam. And our discussion is also attended by representatives from the Departments of Information and Communication of provinces, international and national experts, and representatives from the mass media. And for our discussion today, we will have two main sessions. The first one is on findings from the research review of local government implementation of personal data protection on government-citizen interaction interfaces, and a panel discussion on promoting personal data protection in the public sector. And during the discussion, if you have any questions to the speakers or to the panelists, please leave your questions in the chat box, or you can ask your questions directly. And for the materials, you can scan the QR code on the screen for the language used in this discussion. If you want to use English, you can choose English channel. If you want to listen to and speak Vietnamese, you can choose English from the platform. And to start our discussion, I would like to invite Mr. Nguyễn Lâm Thanh, Vice Chairman of UDCA, and Mr. Patrick Hefman, Deputy Resident Representative of UNDP Vietnam, with the opening remarks. Mr. Nguyễn Lâm Thanh, the floor is yours now. Mr. Patrick Hefman, Deputy Resident Representative of the United Nations Development Programs in Vietnam. Distinguished guests, ladies and gentlemen, and also to all participants joining this event online, virtually. On behalf of the VDCA, may I have an honor to extend our warmest welcome to all of you, and thank you very much for sparing your time to attend this thematic discussion on the review of local government's implementation of personal data protection on government-citizen interaction interfaces 2022. We all know that in recent time, digital transformation has become a buzzword to everyone and every business in Vietnam. And the government of Vietnam has conducted a very important work of the personal identification database for all Vietnamese citizens. And this will serve as the foundation for all public services in Vietnam to be provided online. And the citizens will benefit from this enormously by not having to come to the public offices physically. So that will save a lot of time and costs for citizens, and also making the work of the public authorities more transparent. In recent time, VDCA has organized a series of events discussing the protection of personal data. However, we have not had an opportunity for both the public side and the business representatives to sit down together to discuss the protection of personal data. This is a highly sensitive and also a highly risky area. So how can we identify the risks? How can we mitigate the risks? And that is a very important topic. And we are fortunate to have the involvement of the experts in this area. And our discussion today is attended by experts from UNDP, from the public authorities, from various sectors, gathering in this discussion with the hope that we can analyze this topic and come up with certain findings and suggestions to recommend to the public authorities in order to identify the directions of forward in order to improve the protection of personal data. Because this is still a new area and has not yet received lots of insights. Thank you very much, and I look forward to a fruitful discussion today.
Lam Tang, the Vice Chairman of the Vietnam Digital Communication Association, Dr. Nguyen Quang Dong, the Director of the Institute of Policy Studies and Media Development, distinguished participants from the Central State Agency and Ministries, representative from 63 provinces, provincial departments of information and communication across Vietnam, representative from the media agencies, distinguished panelists, distinguished guests online, and also today here in the Green 1 UN House. On behalf of UNDP, it is a great pleasure to welcome you to today's discussion. It's a very timely discussion, I think, as well, and a very new concept we are discussing today. Vietnam's 2013 constitution recognizes privacy as a fundamental right in Vietnam. As digital transformation of the public sector accelerates, a large amount of data on personal information is being collected online via electronic provincial government portals, the e-government portals, online public administration services, and smart applications put into use by people committees at the provincial level. However, protecting personal data and ensuring user privacy on those platforms have not been received adequate attention so far. There are still several gaps in policies of those platforms to meet the current legal provision, especially in comparison with good international and local practices. Protecting personal data is of great importance for two fundamental reasons. First, to build trust in users, especially in citizens, and thus encouraging them to participate more actively in e-governance and digital government endeavors that Vietnam is in pursuit of. And secondly, to ensure respect for human rights and fundamental freedom of individuals, in particular the right to privacy. In that context, we at the United Nations Development Programme in Vietnam and the Institute of Policy Studies and Media Development have commissioned the review to assess the provincial government performance in personal data protection on the digital environment and promote the best practices in this area. As Vietnam Provincial Governance and Public Administration Performance Index, or the PAPI Index survey in 2020 and 2021 revealed, provinces across the country received very low scores in e-governance from their citizens, despite significant efforts to accelerate Vietnam's digital transformation over the last 2 years. While lockdowns and COVID-19 preventive measures required many aspects of citizens' lives to move onto the online realm, PAPI data shows a very low use of e-government portals and e-services. Moreover, less than 4% of the respondents used the national e-service portal in both years. As we have learned from experience in other countries, digital transformation must be inclusive and citizen-centric to leave no one behind. To do so, key principles on personal data protection, as guided by the United Nations, should be observed. These principles in collecting and processing of personal data include, among others, a fair and legitimate processing, purpose specification, proportionality and necessity, retention, transparency, and accountability. Ladies and gentlemen, you were here today from the presentations this morning. Findings from the review will provide you with insights into personal data and privacy protection practices on e-government portals and online public service portals of all the 63 provinces and municipalities, as well as the smart applications being put into use in 50 provinces. I wish to mention beforehand 3 key findings from the review that I find of great significance and importance, food for thought. Only 4 out of the 63 e-government portals and 3 out of the 63 e-service portals have published provincial government statutes to implement personal data and privacy protection according to the national regulations on this matter. Of the 50 provinces that operate smart apps to interact with citizens, 32 have posted privacy protection policies as required by Google Play and Apple Store. Although regulations on information security issues issued by the local government can be easily assessed online, of all 63 provinces, 59 provinces have not posted policies or e-contracts on personal data protection on their e-government portals, and 60 provinces have not done so of their e-service portal. Moreover, most provincial platforms only require users to confirm that the information they provide is accurate, but do not have the tools for users to express their privacy preferences. Furthermore, none of the government citizens' interactive platforms have fully met the requirements of Vietnam's laws related to privacy in the digital environment in this review, like the law on cyber information security and the law on information technology. Specifically, out of the privacy policies of 39 provinces, 16 are published only in English rather than in Vietnamese, and 22 are in Vietnamese rather than in both languages. We've also noticed good practices in some provinces, such as the personal data protection policy being adopted by Hà Giang province. We hope that Hà Giang can share their experience with other provinces to promote such good practice. These key findings and others from the first ever review will be presented in more detail today by our expert team. We hope that the findings provide important evidence-based data for central and local authorities to have an overview of local government performance in personal data protection. They also help suggest ways to improve personal data and privacy protection and on online government citizens interaction interfaces in both policy and practice. These in turn will help promote trust in digital transformation in the public sector in Vietnam. Let me take this opportunity to acknowledge the important contributions of our partners and individuals that have contributed to this first ever review, especially IPS and our colleagues from UNDP. Our gratitude and thanks to our development partners, what was mentioned in the introduction as well, the Department of Foreign Affairs and Trade of Australia and the Embassy of Ireland for their support and the funding of the PAPI research program. Personally, I look forward to a fruitful discussion today so that we at UNDP can learn from our experts on how to support Vietnam in this endeavor to accelerate digital transformation in the public sector with the first and foremost mission of building trust in users. Thank you so much. Sing, come on.
Thank you very much, Mr. Nguyễn Lâm Thang and Mr. Patrick Huffman for the opening remarks. And now let's come to the findings on the review on local government's implementation of personal data protection on government citizen interaction interfaces 2022. And we've got the presentation to be delivered now. Ladies and gentlemen, as Mr. Nguyễn Lâm Thang and Mr. Patrick Huffman identified, we see the importance of privacy and protection of personal data. When we are sitting here, I could recall that 5 years ago, this was still a very new topic in Vietnam. And when starting discussion on digital transformation and digital economy, we were among the first organizations and individuals talking about privacy and the importance of protecting privacy and personal data in this context. And at that time, 5 years ago, our voice was rare. However, after 5 years, now we have seen significant changes. And the government is already in the final stage of adopting a decree on personal data protection, and the private sector has also been paying increasing attention to that. However, in the public sector, this is still a new and limited area. And I discussed with Mr. Nguyễn Trọng Khánh, one of the main authors of Decree number 47 on data exchange and sharing in the public sector. One of the most important policy documents at the time on exchanging connection and exchange of data in the public sector. And it has a lot of bearings to our discussion today. And I would like to thank our colleagues from the UNDP for working with us on conducting this review on personal data protection implemented by the local governments on various platforms in 2022. This is one of the very fundamental basic reviews for us to have an external and objective view on personal data protection by the public sector at the local level. And we think that sharing with you these initial findings would be an important opportunity for all of us. For my presentation today, first, I'll be talking about the background and research objectives for the review. Second, I will talk about the research methodology adopted in this review. The more important parts are the third and fourth sessions, which are on key findings and policy implications and recommendations. So I will cover the first and the second parts, and my colleague, Ms. Linh, will cover the two remaining parts. As Mr. Nguyễn Lâm Thanh and Mr. Patrick Haysman emphasized, the economic development and growth, and on the other hand, digital transformation have been our key focuses in the last couple of years. E-government is one of the three main pillars besides digital economy and digital society. So we usually use the term e-government or digital government. So from the citizens or public perspective, there are two areas that we could see most obviously. These elements, the online or the digital public service portals and the e-portals of the local governments. So this demonstrates the major focus of the government on promoting digital transformation and improving digital delivery of services and enhancing digital communication with citizens. So provinces have also adopted smart platforms and applications so that citizens can have other ways of interacting with the local governments. So Huế S, for example, is a very popular app in Huế city. And we also see other platforms or portals to facilitate citizens' communication with the government, interactions with the government. Along with this, we have also seen the major risks in terms of violation or infringements of personal data in Vietnam. In Vietnam, there has yet to be a thorough evaluation of economic loss from the public sector's data breach. However, when we look at an IBM Securities research, cost of a data breach report 2021, we can see that the economic loss from the public sector's data breach is significant. From this chart, you could see that the average total cost increased by 10% per year. And for public sector's data breach, the economic loss has been increasing, is even greater. And the growth of this economic loss is around 80%. We see that this is a surge in the cost of the public sector's breaches, while the personal identifiable information is the most stolen information, and it is also the costliest breaches for $180 per case. And we see that for certain sectors such as the labor and social affairs or the justice sectors, it involves a lot of personal data that could be stolen. And from the e-commerce activities, of course, the breaches, the leakage of the personal information is even more. And in Vietnam, we see quite often personal data are being used not for the right purpose. And it is not so uncommon in the public sector. So we see that apart from that, we could also have the concerns about the possible over monitoring or surveillance of personal citizens or personal interactions or behavior. In that context, we have identified the following objectives for the research. The first one is to review the existing regulations on requirements for public sector's personal data protection. And this is to see what regulations are in place and what gaps there are. The second objective is to evaluate execution of responsibilities of local governments in terms of collection, protection, use, and reuse of personal data of citizens. The third objective of the research is to create a baseline assessment for personal data protection practices and document good practices to build national guidelines on the personal data protection in the public sector. And fourthly, we would hope to be able to provide strategic and technical advice on how to improve personal data protection practices. For the research methodology, we select two main areas of data, and the approach of the research and the scope of the research focus on the two main channels: the e-services portals at the national and local governments, and the second one are the e-government portal and smart apps to support local governments. So these are the three online government citizen interaction interfaces. And we only limit or confine our research to publicly available data. So this part only. So the data that we can have access to, and the review also mainly is focused on the personal data being available in the public sector, but we do not cover the whole personal data protection practices in the public sector. So this is how personal data is collected on online platforms. This one is an example from Cà Mau province, and we would see similar screens for other provinces. So we see that all the personal data is provided on these service portals or government portals. Vũng Tàu, for example, we also have this kind of information. For example, the ID number, names, and address. So these are the names at the most basic level. So we conduct our review based on this publicly available information of individuals. And the grounds, the basis for us to conduct this review are the rights that are recognized by our laws and regulations. For example, the rights of the right to informed consent, the right to request investigation, revision, or removal of personal information, the right to request a stopping sharing of personal data with third parties, the right to request compensation, the right to request access to personal data, or the right to restrict content and scope of use of personal data. So this is the rights of data subjects according to Vietnam's legal framework. And correspondingly, there are a number of responsibilities of government agencies in collecting, processing, and using personal data. For example, the responsibility to obtain consent before collecting, processing, and using personal information, or the responsibility to inform about measures, scope, location, and purposes of collecting, processing, and using personal data, or the responsibility to apply relevant management and technical measures to prevent personal information from being lost, stolen, breached, changed, or destroyed. So our review aims to see whether these rights are protected and these responsibilities being implemented. So this is our design of the review targets and dimensions. And you can refer to more details in our full report. In the presentation, we'll focus only on some key criteria. For example, whether or not there are privacy policies put in place in these platforms, or the language accessibility or legal basis for processing personal data, or transfer of data to a third party. So we looked at these 17 review criteria, but in the presentation, we'll focus on some of the key criteria. And for more details, my colleague, Mr. Wu Khánh Linh, will give you a picture. Yes, thank you. To follow up on Mr. Nguyễn Quang Đồng introduction, I would like to share with you the findings of our review and policy implications and recommendations. For the key findings, firstly, we looked at the awareness and attention of local governments to privacy policies. And our finding is that this is still fairly limited. And it is demonstrated in the number of privacy policies that you can find on the reviewed platforms. And as Patrick also already mentioned, only 3 of the 63 provinces had published their privacy policy, which are Thừa Thiên Huế, Đà Nẵng, and Gia Lai. And only 4 e-government portals have these privacy policies of Bình Định, Phú Thọ, Hà Nội, and Thừa Thiên Huế. And this is a very small number when these are the e-public services portals and e-government portals. Only 3 and 4 privacy policies are available. While when we look at the government citizen platforms or interaction apps, which are the non-mandatory applications introduced by 50 provinces, because it is not mandatory. So we see that only 5 out of the 50 platforms of the provinces have this privacy policy. Why so? I mean, I am sorry, more than 30 provinces out of the 50 provinces have this policy. Why do we have this striking difference? It is because the smart apps introduced are mainly on the smart devices of Google and Apple, and these firms have very strict policies requesting for the privacy policies to be introduced and on all the platforms introduced and used on their App Store and Google Store. So for Google Play Store and App Store has these very strict regulations because they comply with the laws on privacy protection in the host countries. And in Vietnam, we only have the draft decree on privacy protection being drafted by the Ministry of Public Security. And one other demonstration of limited awareness and attention to privacy policy is seen in the language accessibility. So we see that when by regulation, when the government agency develop privacy policies or data protection regulations, these policies need to be easily accessible on the digital platforms, digital environments to all users and citizens. And only one situation, in one case of Tiền Giang, publishes these privacy policies in both Vietnamese and English. More than 40% only publish the privacy policies in English. If we identify Vietnamese citizens as the major users of these platforms, the language accessibility constraint actually limits the Vietnamese users from knowing their rights, their privacy rights, and the privacy policy of the owner of the platform. Another evidence of limited attention to privacy policy is the demonstration of the right to consent and to be informed. So citizens, when using these platforms for interacting with the government, they need to have the options to select whether or not to provide this data to be used, and they need to know what they agree to, what they consent with. So the good practice would have to provide a checkbox, a tick box on whether or not the data provider agrees with the privacy policy of the system. So Da Nang has this. However, when we click at this privacy policy, there needs to be details, right? So in many cases, we see this word. However, when we click to that, we cannot find a link, or even if there is a link, there is no content on this privacy policy. So it encourages the good practice of Da Nang to be replicated. So 42 for 42 smart apps, 14 out of this 42 only have the checkbox without the contents of the privacy policy. On the e-services portals, only two pages, two portals provide both the checkbox and the policy. And for the e-portals, only 1 out of 78 provides these both contents. Secondly, there is a lack of full compliance with existing regulations on personal data protection, and the criteria we look at here is the 39 privacy policies. And as you could see here, these are the context for personal data protection provided. However, of the context, only 7 emails were provided, which were are the official public emails of the service providers, meaning that they have the domain with gov.vn. The others are personal emails or emails registered with a service provider or a third party. So if citizens send emails to these mail addresses, there is a high risk of their personal data being stolen. The vendor developing these smart apps on behalf of the government also take charge of the privacy policy for the technical purposes on the platform. So usually they only provide personal email addresses, and it would be very hard to know how these email addresses are being protected or managed. Cần Thơ or Quảng Nam, for example, use the same email address, private one, meaning that these belong to just one owner, and we don't know who owns this email. And if the citizens provide their personal data to these personal emails, they would never know how their personal data would be protected. Another evidence, another demonstration of the lack of compliance with regulations on personal data protection is found when we did this exercise. We sent an email to all the emails that we could contact from these websites or platforms on for personal data protection. And this is an example email. There are two main things: updating information with the ID number. And we expected that when we receive response, the local governments would respond to both elements of this email. So we sent out 130 emails, and these 130 emails were sent and expecting responses for 2 weeks, and only 9 out of these 130 emails received responses, so very low response. And the average time to receive the response is 2.22 days. So if ever they are responded, it's very quick. However, if they are not, then it remains silent. So these are the 17 emails that we received the responses from the privacy policy. These are the number of interfaces providing context for citizens to approach and the rate of the response that we received. So we see that the context for the citizens on personal data protection are actually not there. So we had to use the emails displayed as the context on the main websites of the e-portals or the e-service portals. So with our expectations of receiving responses, we did not. However, we received the unexpected responses. For example, from Kon Tum, you could see that this is a very, very basic, very simple guidelines responding only to the first question or inquiry we had in our email on how to update the ID number. But the second request on accessing to privacy protection policy of the government to give the user confidence on using the e-service portals, that one is not being replied. The response from Tiền Giang is even shorter and also not responding to the second question asked in our email, probing email. And also, you see that the public agencies also have the mechanisms to stop spams or to block the spam emails. However, it makes it more difficult for citizens to send their inquiries in if their emails are screened, are filtered and identified as spams. On the other hand, we have good responses from Bến Tre province e-service portal. The response have very good address line and also specifically responding to each of the questions we raised. So the response is full and detailed to both our questions, and it satisfies our expectations on the level of interaction of the local governments. when they receive questions about privacy data protection. A third observation is an unclear identification of legal responsibilities of government agencies and concerned stakeholders. So this is the unclear responsibilities between the data subjects and the recipients of the subjects or the concerned stakeholders. Only one province, Tiền Giang, on the smart app informs that the data management authority is the Tiền Giang provincial government or provincial people's committee, while in all other privacy policies or in all other platforms gives only very general statements that this portal will collect your personal data and keeps your personal data without specifying a specific owner of this private policy, private data. And we have 5 cases. The departments of information and communications are identified as data controller or data processor. And in 6 other provinces, the ICT system is set as the data controller or owner. And 11 out of 30 apps have the outsourced private entity being the data owner, and vague definition is found in 15 cases. This is an example of Quảng Ninh, Smart Quảng Ninh. And you see that the data owner here is a private third party, AIC. So for the privacy policy, they say that the data owner is now, or the data would be controlled by AIC. When we contact this third party, we got to know that they are no longer active or operating. The app is no longer active. But then we have 10,000 downloads, meaning 10,000 registrations on this smart app. So how should we do with the 10,000 entries of personal data having been collected? As mentioned, we have found 50 smart apps of 50 provinces, but of these 50, only 42 are being active. The remaining are inactive. So for the inactive applications, it's very important that the local governments need to review the status and take proper measures. For the delineation between the entity being responsible for, identification of the entities being responsible for this data protection is very important. For example, in Hậu Giang, they said that the Hậu Giang People's Committee, Provincial People's Committee, is responsible for collecting and managing personal data. So meaning that this data can only be removed when the collector and manager of this personal data allows and deem this data as no longer needed, or when an incident happens to the system, then Hậu Giang Provincial People's Committee has the responsibility to inform to all users that there is an event or an incident with the data, and they are being responsible for this before the users. Now, let me move on to our key recommendations. Our first recommendation is that it is very important to distinguish between data privacy and data security, and we developed this table for comparison. For the target of protection for data security, the target of protection is the ICT system. However, when we talk about data privacy, the target of protection is citizens as users of the ICT platforms. So the substance of data security is to protect data integrity, data confidentiality, and data availability. While for data privacy, The substance is users' rights to personal data, right to informed consent, right to request success, update, revision, removal, privacy of personal data from illegitimate users of those having access to personal data. For the format, the data security would be about technical guidelines, internal regulations, service contracts with the PDP provisions, or for the data privacy, the format would be in the form of consent, notice, or regulatory obligations. So we need to be able to distinguish between the two. Our second recommendation is that it's very important to further develop and improve the legal framework for PDP. There needs to be a law on PDP, even though the MPS is developing a decree on PDP. However, we believe that we need a law, a legal normative document at the level of a law rather than a decree to ensure personal data protection, and it needs to include a clear definition of PDP. Currently, in the draft decree, in the law on the cybersecurity, Article 3, Clause 5, the definition is very broad. Personal data is the information sufficient to identify a person's identity. However, we need to have a very clear definition of personal data. What elements of data it should contain? So the definition in that case is very narrow. Only identification data. In Circular 3025, we have a definition limited to only the automatically collected data on a person. So we hope that the law on personal data protection will give us a very clear definition of personal data, taking into account the current trends and the current developments, emerging developments, because the personal data has now become much more than what was defined 5-10 years ago. We also recommend that we, in such a high-level legal document on PDP, there needs to be a distinction between data controller, data processor, and data subject. And there needs to be consent, in the form of an e-contract, needs to be developed. So there needs to be a sample privacy policy as an e-contract between government agencies and citizens, not just a tick box, right? Because you know that in this digital environment, there have emerged new forms of interactions like digital signature, and a tick in the checkbox here is also equal to like an e-contract signature. So it's very important to develop this privacy policy and its legal status. Next, we recommend that there needs to be a dedicated person to be in charge of PDP at the local level, at the provincial level. So at least one data protection officer needs to be appointed at the local government level, and the main function of such a data protection officer would be to inform and advise, to monitor compliance, and to act as a contact point with supervisory authority and data subjects. And also, the provinces, the government agencies need to publish the data protection officer's profile. Then, in terms of monitoring and evaluation of PDP practices by government agencies, we recommend that there needs to be an improved transparency about data breach incidents and privacy impact evaluation. We've got a good practice from Hậu Giang. In the privacy policy, there is a very clear statement that in case of cyber attack or personal data incident, the Provincial People's Committee will take action, will take charge of informing the data owner, the data citizens on such a breach incidents. And there has been also an observation on the abuse of the data protection. And Đồng Nai had an incident of abusing the information for the wrong purpose. And Đồng Nai also disclosed that incident and also published the action taken by the provincial government on dealing with the incident and urging the relevant government agency and DNPT in Dong Nai to tackle the problem. So those are the two examples of good practices on transparency of data breach incidents. What we mean here is that the absolute confidentiality in this digital era is very challenging, very difficult. But the culture that we should have is to ensure transparency about any incidents, any breaches, and be willing to cooperate with the people to deal with the consequences, problems. So cooperation with the citizens is very important to make sure that any incidents or problems would be addressed properly. Second, we recommend to include PDP indicators in the Ministry of Information and Communications Digital Transformation Index, the DTI. So the DTI was initiated the MIC and was put in place, and we will hear from the representative from the MIC on this point. The third the third recommendation regarding this M&E of PDP practices is about independent review or rating of the public sector's PDP by business associations. So that brings me to the end of our presentation. Still very preliminary and still only the top of the iceberg. But we hope that this serves as a foundation, the basis to our discussion. And we hope to hear your inputs and your suggestions so that we can improve these review criteria to guide our assessment and evaluation of the performance of PDP in the public sector in Vietnam. IPS, we from IPS have been involved in two events on development of open data, and the second one by the ASEAN Secretariat. The ASEAN Secretariat is on digital identification in ASEAN region. And there is a presentation by a World Bank expert from EU example, and he said that EU has introduced a digital e-wallet for EU based on digital identification, and trust and confidence is very important. So it needs to be institutionalized. It needs to be operationalized and officialized on through our legal framework, and needs to be complied with, needs to be observed by our public sector. Thank you very much for your listening. Thank you very much, Mr. Nguyễn Quang Đồng and Ms. Tống Khánh Linh, for your presentation. And now we will come to the panel discussion on promoting the PDP in the public sector. And the plenary session will be moderated by Mr. Nguyễn Quang Đồng and Ms. Đỗ Thanh Huyền from UNDP. And this panel session will be attended by Mr. Nguyễn Dương Anh, Vice Director of Thừa Thiên Huế CIP, Mr. Nguyễn Trọng Khánh, MIC, Ms. Nguyễn Kim Thoa, the former Director of Department of Criminal and Administrative Law, MOJ, Mr. Huỳnh Thiên Tứ, Lecturer of the School of Law, University of Economics, Ho Chi Minh City, College of Economics, Law and Government, Mr. Nguyễn Dương Anh, Mr. Hoàng Minh Hiếu, and Mr. Huỳnh Thiên Tứ will be participating virtually. Well, thank you very much, ladies and gentlemen. Allow us to start this plenary discussion, the second session of our the panel discussion, the second part of our discussion. An apology from the organizers that Mr. Hoàng Minh Hiếu, standing member of Law Commission of the National Assembly, has an urgent meeting at the Law Commission and he cannot be here with us today. So attending our panel discussion, we would like to introduce Madam Nguyễn Thị Kim Thoa, a former director of the Department of Criminal and Administrative Laws of the Ministry of Justice. And she had a doctor degree of public law in Germany. And we still recall that we had a lot of interactions with Madame Thoa back when she was one of the key persons in drafting the law on cybersecurity, and Ms. Kim Thoa is now still a lecturer at the Judicial Academy and Ho Chi Minh National Academy of Politics. Mr. Nguyễn Trọng Khoánh is currently the head of Division of Infrastructure and Digital Data, Authority of Information Technology Application, Ministry of Information and Communication. And this is one of the key agencies in promoting digital transformation, particularly at the local level. So his department has played the important role, the key role in digital transformation in the public sector. And he's also directly involved in supporting the steering committee on digital transformation. Thank you, Mr. Khánh, for attending the discussion with us. Attending the discussion virtually, we've got Mr. Nguyễn Dương Anh, Vice Director of Thừa Thiên Huế Center for Information and Technology. Mr. Dương Anh, can you hear as well? Yes, Mr. Đồng, I can hear loud and clear. Mr. Dương Anh used to be the Managing Director of the Smart City Center, Huế IOC, from 2019-2021. Before that, he had 17 years in the Technology Center and Information of Thừa Thiên Huế, focusing on conducting research and adopting e-government application. And Mr. Dương Anh has been very close to us because all study tours on Huế Smart City has been guided and facilitated by Mr. Dương Anh. Thank you, Mr. Dương Anh, for your cooperation. And the final panelist is Mr. Huỳnh Kim Tứ, a young lecturer of the School of Law, University of Economics, Ho Chi Minh City, for the College of Economics, Law and Government. He is also a researcher on philosophy and laws on data, personal data protection and privacy. And he has published a lot of articles on the Tia Sáng or Kinh tế Sài Gòn, the Saigon Economics Review. We have also invited representatives from the DIC of provinces and the International Communication Association Alliance. We hope that the International Communication Alliance representative can also give us your observations and advice. So we would like to ask the first question to Ms. Nguyễn Thị Kim Thoa. What are your general observations on the current legal regulations on privacy protection, particularly the practices in the public sector? Yes, good morning, everyone. I'm very glad that we have this platform today for us to share our views and observations on our legal framework on personal data protection. And what is the status of the the regulatory framework now? And what are the gaps to be filled? From the legal perspective, we talk a lot about personal data protection, privacy, but what they are about? Whether do we have sufficient regulations and laws on that? We have heard some discussion or some mentioning about the legal protection in the Constitution on privacy. But then we have the civil code, very ambiguous, mentioning or alluding to personal data. Most recently, we have the law on children with some more specific article or regulation on data, personal data. Understanding how should personal data, Article 33, if I'm not mistaken. So the definition is given there. However, it's only about children. Children don't have accounts. Children still do not have so many risky and sensitive personal information to be disclosed or to be leaked. But legally speaking, there had yet to be any legal documents with clear definition of personal data. When I looked at the review report by presented by Mr. Dong and Ms. Ling, we all see that, okay, we don't have sufficient legal regulations or definitions even on personal privacy, personal data, and personal secrets or confidentiality. So we are also familiar with the term digital government, digital economy, digital society, right? Everything is digital. Digitalization, everything is put online, and that can save our people from sweating on the way, traveling or cycling to the public offices for any service they want to receive. And digitization would ease a lot of their efforts. I recall that 2 months ago, I had to obtain a certificate on the marital status. And I told my daughter to search on the e-portal, e-service portal of the government. And 10 minutes, she could search how to do it, right? And then we have to put the personal information up there. And then there is a question as to whether we want to come to the office to get the result or get the result to be sent to my home. And then I told my daughter to tick that I received the result at home. And it took only 3 days for me to receive the certificate. It's very convenient, right? Yes, and we feel good about it. However, there is one concern here. My personal data has already been provided to the government authority, to the public authority. How will it be used? Can it be leaked to other people? Can it be used for other purposes? Or is it being used only for the purpose of obtaining this marital status certificate? And then my friend in Germany sent me an invitation to go to Germany for a visit. And then they commit in the invitation, there is a statement that all your personal data will only be used for this purpose of inviting your relative, your family member to go and visit Germany, and also requesting some specific information, right? Like what are my economic conditions to prove that I have the possibility and the means to invite a guest to my home, for example. So that's very clear that the personal data being provided will only be used for the very purpose for which we declare our information. Very clear, very transparent. What about Vietnam? We are now having public administrative reform. And in recent years, we said that we want to be able to provide public services at level 4, right? Level 1 only provide data, level 2 having a form, level 3 filling in with all the personal data, and level 4 these services will be delivered online. Very good, right? And that is also one focus for the public administrative reform in the coming years. In this context, PAR is very important. And what we care about is the level of a public service being provided. Mr. Dong and Ms. Ling also refer to digital economy, sharing economy. Whenever we do a commercial transaction, a buying transaction online, we provide our information, right? And then e-governments, because all the government agencies now work online. It's very convenient. We protect the environment, but then how to protect personal data? It's a very big issue in the current context because we have no way back. We cannot afford not to do it, right? But how to do it? What do we lack here? While the Constitution says this is a right, right? The right to personal privacy, and also Article 24 of the Constitution also says that only laws can protect your right to privacy. However, in certain cases, for the public health purpose or for the national security purpose, social order, then the rights restrictions can apply, and only a law can restrict these rights. So I saw that you have a term of proportionality, right? And corresponding. So it means that when you have the rights, you should have also, on the other hand, responsibilities, corresponding responsibilities to protect these personal data. I understand that the decree on personal data protection is being drafted and submitted. MOJ also proposed several years ago that we need to develop a law on PDP. However, for many reasons, the proposal has not yet been accepted to be in the legislation making agenda of the government. But I believe that such a law would be necessary. And if we talk about a law, what should be contained in the law? How should we understand about privacy, personal data, and PDP? Second, we need to look at the responsibilities of public authorities in protecting and using personal data. And it needs to be a very clear distinction of different actors here. Responsibilities of respective agencies and authorities in collecting personal data, storing, managing, and using the personal data. So I receive hundreds of calls a day, right? And then it is for all every possible purposes, like telesales also. So who should be responsible for all of this? And what should be the responsibility of the public agencies when they are in possession of all these personal data? and how they are supposed to remove. What is a timeline for removal of personal data when no longer needed or would be used for the purpose that the person provides it for? And also there needs to be sanctions for abusers, right? And the rights of the people with personal data being breached, being abused. And, you know, without sanctions, then the legal framework would not be effective, would not be meaningful. So we have the administrative sanctions and we have criminal sanctions. There needs to be proper sanctions under both administrative and criminal mechanisms. Sanctions should be provided under these two different mechanisms, different avenues, to serve as the basis for both the public authorities and citizens to have the confidence in using the digital platforms. Most importantly here is that we need to have the proper legal framework for people to comply with. The legal basis for the government agencies to operate transparently, clearly, openly, and to give the confidence to citizens to use the platform. Yeah, thank you. Thank you very much, Ms. Thoa, for your insights into the issues related to the legal framework, and also your support to the view of the research team, the review team on the necessity of the law on PDP. You also mentioned the digital society, but and you are right that between digital economy, digital government, and digital society, there have been new developments. However, from many of these developments, we have the reasons for concern. For example, the government of Hanoi city has said something in the line of, you know, using the personal data for digital economy. So if personal data can be sold, can be shared to promote digital economy, that gives more concern than the reason to be happy to our citizens, right? Next, we would like to invite a speaker, a panelist, Mr. Huỳnh Thiên Tứ from Ho Chi Minh City. Mr. Đồng already introduced Mr. Tứ background. So we have some questions to Mr. Tứ, and we hope to hear from you from the approach and the philosophy of this review. What are your comments on the findings of this review in the first place? And secondly, in your opinion, how PDP would contribute to protecting the citizens of privacy from the academic and research perspective? And thirdly, how should the privacy protection and personal data protection need to be reflected from the legal perspective? So we want to hear from you as a legal researcher. Mr. Tứ, the floor is yours. Thank you very much. Thank you for Mr. Đồng and Ms. Huyền introduction. For the questions that Ms. Huyền just asked, I would like to share with you some observations and some views, personal views. And I have to say that I am speaking from the theoretical, conceptual perspective. The theories that I have researched has given me interesting views to be shared with you today. So I will not deep dive into practical aspects. So I will talk purely from the theoretical, conceptual perspective. With regard to the review that we have heard about today, and from my reading of the reports, I highly appreciate this methodology because the research is mainly conducted based on the practical, empirical experience. So I could see that the review, the assessment already looked at each and every e-portals, e-service portals, e-government portals, and smart apps of the provinces from the very practical point of view. So I highly appreciate this approach and methodology. From the reviews, reports, we can see that PDP currently in Vietnam is, very in a very not safe situation without clear policies and guidelines or guidance at the top, at the conceptual level, and even more so, risky and loose at the practical level. That's why it's very important for us to raise the awareness for the both public and private sector when it comes to PDP. Responding to Ms. Huyen's question on how to operationalize the philosophy of privacy protection in our legal framework in the for the public sector from the philosophical point of view. There are many philosophical and theoretical views that have considered digital transformation and the digital world as something not real, right? The digital world is something that is not a real world, and it does not follow the real world's principles or rules. And this view started from the initial years of the 2000s. The digital world was very new. That's why there was such a myth or misunderstanding about digital world. However, currently, the view is that we should not see the digital world as a separate, non-real world, because the digital world has already changed. And even though it requires for the changes of people's behavior to adapt to it, but it also adapts to the real world. It is no longer the virtual world, the metaverse that we've heard about in the past. And I'd like to quote Professor Julie Cohen's view, who is a professor at the Georgetown University. And she made a very famous statement that technology does not remove the body, but it only changes the experience of the body, the physical body. And it has two implications. The first implication is that all entities, all subjects, today we are talking about public authorities, right, should not regard protection of data a new task or a strange task. It is not a new, alien, strange task. Supposedly, protection of information and personal data has to be and should have been considered as the integral task of the public authorities, because the citizens' information is on the household book, on the IDs cards, and on every database of the public authorities. So the public authorities should regard protection of personal data as an integral part of their job. They should not regard this as a new task, new obligation. The second implication of such a statement is that citizens now will have a different experience of privacy, the right to privacy, when they interact with public authorities from these digital platforms. Right to privacy in this new context will have to be displayed or transformed into relevant rights and responsibilities, which involve the control of personal data flow. So control of personal data flow. And this control is very important. But the control mechanisms need to be different depending on whether the citizen interacts with the public sector or the private sector. So for the private sector, we can encourage the agreement, exchange, negotiations, and in the near future, exchanging, selling, buying personal data, of course, is still ensuring the principles of privacy protection. However, for the public sector, there can be certain discretion. Whether or not we can have this discretion, my view is no. If possible, we can only adopt the good practice of the code of conduct or higher than that. The regulations or the good practices are at the high level, the code of conduct in the public sector. And we should also encourage and provide support to promote good practices in dealing with personal data, because the realities show that personal data is everywhere, is on every public paper, right? And it can appear on any operation that you have on the public domain, right? You just need to leave your screen open for the personal data to be tampered or to be abused. So we need to organize very good training for the good practices to be complied with, to be observed in the public sector, to ensure that privacy is protected. So to address the concerns that we've mentioned, the review report that we have heard today is one of the first initial findings, and it should not be the last evaluation of this topic. Thank you. Thank you, Mr. Tứ. Even though you say that your views is highly theoretical, it's very useful for guiding the practical experience. We should not separate the digital world as a virtual world, non-real world, from our practical world here, right? Physical world here. So whatever we do, it needs to be relevant to both the digital environment and the physical environment. And it should not be just for the virtual environment. And from what Ms. Thoa said, we're also glad to see that it seems that things are now going in the right track to address our expectations. So for example, we have the initial grounds for the rights to privacy, to transfer the data to a third party, etc. So the principles are there, right? And they can be concretized, they can be institutionalized into our laws, our systems. However, I still have a concern. It seems that such regulations or principles seem to apply more to the private sector rather than the public sector. So we want to see that the privacy protection here should also apply to the public sector. And it should govern the EU, for example, they have the directive to guide both public sector and the private sector, even though they have a separate guidelines for the public sector as well. So we see that the movements seems to have been pacing up, have seemed to be accelerating. We understand that Mr. Khánh has been deeply involved in developing the systems and exploiting and using data in the public sector as well as protecting the data. So you should have considered these aspects quite at length already. We also understand that your agency is now also developing documents, and some of the documents that have just been adopted. So what are the general directions and the plans to improve the processes and regulations on PDP? What are they to avoid the discretionary practices of the public authorities at the moment? Mr. Khang, we want to hear from you. Thank you, Mr. Dong. I work at an agency that promotes digital transformation more than being restrictive or controlling the digital transformation or digital operations. So from our perspective, I mean, such a review is very informative and very useful. When government agencies introduce or provide public services to citizens, the PDP is becoming even more important, and it's very important for us to develop more comprehensive, more effective systems for our people. So digital platforms are useful instruments. Regarding the findings of this research, I would like to make some comments that you can consider for further improvement. From your presentation, I found the review is more about, it seems to be more about assessing the social platforms rather than, addressing or assessing the public sector platforms. Because when you assess government platforms, you need to focus more on recommending on how to improve their systems. In public authorities, for example, the systems are owned by the government agencies and they have to comply with legal framework, legal regulations and requirements. So the private sector can develop their apps, their e-portals in their own way, governed by the regulations for the private sector. And for the public authorities, the processes and the procedures, they need to follow the government's processes and regulations. And they cannot be arbitrary. They cannot be discretionary as the private sectors. And it seems that you focus a lot on collection of personal data. But, this is the information that the citizens disclose or report, provide to the public authorities to serve their own purpose, right? They need a service to be provided by the public authority, and they provide this data. So that would give us a different perspective, right? The system for the government to serve its own interest and the systems that the government uses to serve the citizens' interest. So sometimes it is different. When the citizens send in their information through the e-government portals, the forms and templates are being filled in and kept and monitored under the requirements of the laws and regulations. And so it is not that easy to, remove the information from the systems. It's different from a private service provider because for the government agencies, they need to comply with the laws and regulations as to for how long this data should be kept and how it should be stored. So the concerns about disclosing the information, for example, leaking the phone numbers of citizens for telesales, for example, I believe that it would be mostly attributed to or caused by the private sector's operations rather than the public sector's platforms. In terms of the legal framework development, my view is that as I am involved in developing the database and digital transformation, I see that the balance between protection and promotion is very important. If we are over concerned without proper grounds, then it may limit the sharing and exchanging of information. That would limit, in turn, it would limit the delivery of public services to citizens in a convenient manner. And it would add more cumbersome procedures to citizens. And citizens may find more hurdles in having to provide information to one government agency and then another public agency for their own services, for their own purpose. I think that sharing data is very important for daily life activities of our citizens, and we need to promote and facilitate it. But of course, how to share information and protect citizens' rights and interests at the same time, there needs to be a balance. We need to strike this balance between promotion and protection. Our view in terms of protecting personal data is broader. I mean, protecting information security and personal data protection is part of it. And our view is that we need to design a good break, right? In order to be able to accelerate. So if we want to speed up our digital transformation, I totally agree that we need to design a very good break here, without which the digital transformation can be at risk. And MIC is also paying a lot of attention to this topic. And in our DTI, Digital Transformation Index, there is an important component of information security protection with all of its sub-elements. So information security protection for the public sector is identified to be achieved at 4 levels by the MIC. The first one is to respond to timely to incident. The second layer here, the second level here, is the professional entity to respond to incidents. The third layer of security here is an external or independent evaluator engagement to ensure information security protection, including personal data protection or personal privacy protection. And the fourth level is the top level of the system security assurance. So those are the 4 layers of information security that are in the view of the MIC. So of course, we should always be alert and vigilant and following all the new developments. And recently, on the online public services has also been amended. Before it included only websites service delivery, but now it is expanded to other interaction platforms, including the smart applications on the mobile devices. So the more channel of services, the more convenient it is for citizens, but also the more concern it raises and the more it requires about privacy protection. So I believe that we will work together to continue to review and revise our policies in an appropriate manner. Thank you. Thank you, Mr. Khánh, for your views. It is quite true that from the perspective of a promoter of digital government and digital economy, we all agree that good breaks are very important. And one of these breaks is that the government authorities need to look at and to monitor the break that they create to protect personal data. The reason why we conduct this research is because we looked at the wide range of the e-government portals and the service portals to see how citizens' data are protected, because people provide a lot of their personal information everywhere in the country, and many government agencies have put up all the citizens' personal information up there, including their names, addresses, and emails, and numbers of telephone numbers. And you know that there are myriad softwares that can extract all this personal data to harass people. So the reason why we are doing this job is to just give a reminder to governments to be reminded of their responsibility of protecting this data. And one of the programs we've been following is the dialogue program between Ho Chi Minh City's government and people. And in the initial sessions, the citizens put up their phone numbers there because they need the support from local governments to respond to their very urgent needs. And then after several sessions, as I learned from people in the public sector, that this is risky, this is very sensitive. So that concern was taken. So all the personal data are received by the system, but not disclosed publicly. So they are protected. And no longer disclosed. So that was a good reaction. So I hope that the government would not say that we will sell your personal data for promoting digital economy, right? Because the first and foremost, governments need to protect their citizens rather than sharing or using their personal data for business purpose. But of course, how to do the business is the issue of public service ethics. That is another topic. Now I would like to address Mr. Nguyễn Dương Anh, Vice Director of Thừa Thiên Huế Center for Information and Technology. In Ms. Ling's presentation, Thừa Thiên Huế is portrayed as a showcase of good practice of interaction between the government and citizens. We had an opportunity to work with Thừa Thiên Huế Center for Public Services, and we got to know about the high level of interest by the Department of Information and Communication of Thừa Thiên Huế to this topic. So we've been working together in order to improve this platform, to make it more user-friendly to citizens. And one of the key features is to protect people from being harassed by having their data stolen or leaked out. And I'd like to ask Mr. Dương Anh to share with us your views and your comments. So Thừa Thiên Huế is mentioned as a good example, a good practice. So as a person responsible for the IOC of Thừa Thiên Huế, what have you done to have this good result and have this good reputation? What are the special processes, practices, and approaches that you have undertaken to have these good results? And what experience would you like to share with us, and with which you can tell us that we can do it as well? Mr. Dương Anh, please. Yes, good morning, Mr. Dong, Ms. Huyen, panelists, co-chairs, and participants to the webinar today, ladies and gentlemen. Responding to your question, my view is both based on the principles of public service and also based on my own observations. I want to say that there are different laws and regulations on private or personal secrecy and privacy, personal data, and there are also regulations on protecting personal data. I can confirm that there are such regulations and requirements. If any, they are not, highly visible, or they are not very well structured or organized, maybe. However, we can leverage on the existing regulations already in order to be good practitioners, right? So if anyone abuses my personal data, or if anyone violates the principles of digital transactions, or my social security, social insurance data is leaked, or my tax data is leaked, etc. Or if I have provided my data to the law enforcement agencies, for example, if such data is abused, there are mechanisms for me to seek justice. From a practical point of view, there needs to be a better organization or arrangements of these regulations and principles and rules to facilitate our work. Because, every time we receive a request from citizen, we have to dig in the pile of regulations to ensure that we can deliver our service to citizens in a proper manner. And there are advantages in the public service. As Mr. Khánh mentioned, the requirements that we need to adhere to are fairly clear for us to perform our public service. So there is no need for us to deep dive into personal data, and the transactions that we have with the citizens are deemed as, for the public purpose, data for public purpose. So once these data are used for the public purpose, then we have mechanisms to ensure that the data is being used for the right purpose. So that is an advantage. We don't need to treat this information as personal data, family data, data from a digital transaction. However, once this data is provided for the public purpose, public service purpose, all the regulations and principles should be adhered to. At the moment, our observations tell us that when citizens use public services, citizens themselves are not aware and don't have the high level of awareness on how to protect themselves. Even though we protect the code of public service conduct here, we encourage people to be aware of their own rights and responsibilities in protecting their own personal data. There is a habit by the citizens that whenever they use a new application or to do something for their own interests, they would automatically agree to the policy in a matter of millisecond. They would tick the agree box just in order to use a service. So, there is no wonder why you receive so many calls, spam calls, telesales, offering something to buy. No strange at all, because there may be someday you go to a website, you download a document, or you install an application for your own interest, and the terms and conditions for use of that application always have a tick box, right? And you tick that box to use the service, and then you never read the contents. So you need to have these skills when you interact with a digital platform. You know, an ordinary average citizen would find it very easy to ignore all of this. And in Hue, when we launched our first version of Smart City, we have a section on responses or feedbacks. So we encourage people to provide their feedbacks, and we understand their concerns. So, you know, when they are invited to provide feedback, their concern is that their feedback may be disclosed. So even though we have the regulations on confidentiality, but we would double down on it. We tell the people that every information you send to us will be kept confidential. They would not trust it immediately. They had to test and try in the first year for not so sensitive issues in 2021. But in 2022, the complaints we received from the people are highly sensitive and hot topics, hot problems. Why do they dare to report on those things now? Because they have the trust that their private data is strictly protected. And the government agency receives this information not for any other purpose. And they are brave enough to accept this information and to take this information seriously. So the people have tested us and they see it. So legitimately, they can share their concern, they can report problems that they can observe in the public sector, and they see that their problems get addressed, get responded to, get taken seriously. So on the one hand, we make it very transparent to the people, and on the other hand, in our working regulations, we also double down on the principle, on the understanding that if we lose citizens' trust, there is no way for us to bring them back. Because even if we invest heaps of money into our system, if people don't trust to use it, then it is just a waste of money. So we had the People's Committee support us in introducing working regulations with a very strong and strict principles of public services. For example, we have the delegation of authority, very clear delegation of authority, the authorization from the Provincial People's Committee for us to work on it. And it is not easy, you know, because we are just a second level public service provider. And it is not easy to have this level of authorization, because now we work on par with the departmental agencies of the province, like the Department of Public Security, for example. We are just the second level of secondary public service provider, public service agency, but we received the authorization by the Provincial People's Committee of receiving and distributing the complaints of the people to respective provincial agencies. And it is a testimony of high political will of our provincial governments. And also, whenever we receive a report on personal data protection, we have the log with anyone who may have had access to such personal data. And if a personnel, IOC personnel, for example, is found to be the one who had access to the information and abused the information, should be held to account. So this is a very strong control, very strong mechanism. And we once received a call from a citizen, and he asked that why I just reported this case yesterday, and right the day after, some people came to my home and harassing my family. Did you leak the information? Did you leak my reports outside? And we were worried. We took that very seriously to find whether a person accidentally disclosed that information. And we found out that when sending this complaint to IOC, the complainant was not, confident. That's why they came to their Facebook, okay, and they informed on the Facebook. So they actually leaked the information on their Facebook, not on our website. So we would tell them that, okay, this is about your skills in making complaints, and it is the fault is not the system's fault, our system's fault. And now we have 870,000 accounts registered by citizens and businesses. And as Mr. Khánh said, we try to avoid the people from the hurdle of having to fill in their data multiple times. We have the pre-fill feature for the citizens to go to their own account. And once they have this account and the log account, they would do the subsequent operations more conveniently, but it also provides a feature to trace the operations by citizens, by users, to know who has access to the system, what transactions or what operations were made. So the tracing feature is a good thing to enhance confidence as well. So finally, I just want to say that while we certainly will have to organize our legal framework more fully and in a more advanced manner, but we don't start from scratch. We already have ingredients. We already have something to start with. And also, secondly, the principles, the requirements for the public service also provide us a general safeguard for us to protect personal data and protect business data and to give trust to citizens. And thirdly, it's very important to improve awareness raising and education. And we need to combine our communication and dissemination with initiatives, with creative ways of working to convince our citizens. Our citizens are very open, and once they are convinced, they will be encouraged and incentivized to work with us. You know, in the past, it may take them 1 month to send a complaint to us to get a response. But now we have other creative, more efficient and effective ways to stimulate this interest from the people, to make them believe that from now on, it will be much more convenient for them, more easy and more effective for them to use our digital platforms to interact with public authorities. So that's from my side. Thank you. Thank you, Mr. Dương Anh. One suggestion from Ms. Ling's presentation that there needs to be a dedicated information officer or data protection officer from the public authority. So what is your view about that? Should we have a dedicated staff for that job, or should we do we have to be satisfied with a person with 2 jobs? Yeah, so part-time officer for this purpose. Yes, responding to this point, you know, having a dedicated officer is a common way of thinking, because we tend to think that we don't do this job because we don't have a person to do it. However, now we need to approach it from another angle. Once we are aware of what needs to be done and we have the technology, we have system support, we can design it, build this feature in the system. And we don't need a person dedicated to be on top of it. And in an agency, there is an IT officer, and we just need to add these tasks into this role, the IT officer role. So the IT officer would be in charge of everything related to the system, and we don't need to appoint an entirely a new person, right? Because if we just one person for a big network, one person, is it enough? If we introduce another system, does it mean that we need another person? No. Technologies are there to help us to work with many more hands, many more heads, and many more fits, right? So I think that technology can solve the problem without having to appoint a dedicated officer in charge of data privacy. However, whatever we do, we need to be well aware of the specific circumstances. So perhaps Ms. Ling's recommendation may be appropriate for certain circumstances that I missed in the presentation. So I'm sorry, I cannot respond to this question directly. Thank you, Mr. Dương Anh. On behalf of the research team, we also want to respond that the data officer here does not mean a new staff, an entire staff, but a role. What we mean here is a role of data privacy, data protection, or a job description for that role. But the person, the physical person, can be, you know, for different existing positions already in the public authority. So that's what we mean. But all in all, Mr. Dương Anh's responses and views are, as always, are very valuable to us. Okay, so I totally agree that we need to be able to document the good practices of Thừa Thiên Huế to share with other agencies and other provinces. And as Mr. Dương Anh said, you have hundreds of delegations coming to Thừa Thiên Huế, learning about IOC's model. So we hope that your practices, your processes and procedures can get documented, to be replicated and to be shared widely with other colleagues. Yes, because it is great that we could have these good practices already in your province. A final point, also related to Mr. Khang's comment on the balance to be stricken between protection and promotion. And I understand that you have been working on designing such a set of principles to strike that balance between promotion and promotion. And we've got development initiatives representative, Mr. Chung, Pirate Chung. And I'd like to ask you, how can we strike a balance between the two objectives of collecting data, processing data, and then using the data without compromising the personal privacy, right to privacy in other countries? Mr. Chung, can you share with us your views and your experience?
Hi, can you hear me? Can you hear me?
Yes, we can hear you
Okay.
very well. Yes, please
okay,
go
thank
ahead.
you. Thank you, and thank you, everyone.
Xin lỗi là cái mặt.
Thank you for inviting me to talk and offer my thoughts about this discussion. It's such a rich discussion, and I'm so pleased that IPS is engaged in this process and with the support of other agencies. It's so invaluable to think about the transition to digitization and how that implements human rights. And specifically as an organization and institution that works in the nexus between human rights and digital transformation, specifically looking at open data and data governance issues, I think we tend to silo these issues. And it's important to think, well, this is how I think about it, is that we as human beings, physical human beings, are persons with traits, physical traits, and identity. And when we transition that identity into a digital form, the same abuses and violations to our person and our human rights gets also translated into the digital space. And it can actually be increased or amplified to a certain extent that is now disconnected to our physical person at a certain point because it's virtual, but it also can be then reconnected to our persons and used abusively to abuse our human rights as people physically. And so I think these discussions are really valuable in terms of starting to recognize those linkages and connections between identity in person and in the digital space. In terms of data protection laws and data privacy, personal data protections, these discussions are new, and they're new globally. It's not just part of Vietnam. But we also need to contextualize the context that we're working in within Southeast Asia more broadly, but also in Vietnam's context. And increasing legislation does not necessarily mean increased compliance. So to ensure increased compliance with laws that are built around frameworks to protect people, we need to be able to institutionalize them, like many of the panelists have raised and mentioned, but also build the capacity in order to enact them and uphold them. And I think this is potentially where there are huge gaps that are missing in terms of the capacity to do this and follow regulations that make sense to people. And the ability for citizens to also understand those frameworks and legislations and have the capacity to act as citizens. So it's the responsibility all over in terms of all stakeholders as part of general society, right? And I think this is a real gap that I didn't see in the report yet, in terms of where are the opportunities here to raise awareness more broadly and capacities in government institutions, in private sector, and among citizens themselves. The other thing that I saw or wanted to ask the researchers is, to what extent did the study actually look at who is using e-government portals? what are the demographics that are accessing these systems, and which are the demographics that are not accessing these systems, and why? And if we understand these dynamics as well, we can understand how to build systems that are more fit for purpose and that also allow citizens to co-create systems that are more suitable for their needs. And especially for marginalized communities or disadvantaged communities who have limited access to connectivity or devices, etc. How are we connecting and bridging some of those gaps? And understanding who is currently using these systems may identify who is not using these systems. And in that way, we can try to bridge some of those gaps as well. I did have another third point, and that was around identity. And my second question is around, has the government in Vietnam or other developing agencies within Vietnam looked at or investigated digital identity systems that are based upon self-sovereign identity systems? Self-sovereign identity systems enabling citizens themselves to control and use their own identity to engage with governments. And so a decentralized approach to where the rights of the citizen's identity is actually controlled by themselves and not a third party, corporate agency, or a government agency. And I wondered if this has been something that is discussed or being discussed in Vietnam. Thank you.
Thank you very much, Mrs. Chung, for sharing with us your also thoughts and questions, which are so valuable. Now I need to switch to Vietnamese so that my colleagues here can listen to the panel. Cảm ơn bà Chung rất là nhiều. Thực ra thì những cái chia sẻ của bà vừa rồi cũng rất là quan trọng. Đúng là chúng ta biết rằng là có những khoảng cách giữa cái việc là các cái quy định của pháp luật rồi với cái việc là tuân thủ, đúng không ạ? Tuân thủ của các bên. Trong đó có cả cái sự tham gia của người dân nữa, người dùng trong cái môi trường số hiện nay. Làm thế nào đấy để có thể cải thiện được cái hiểu biết của người dân nói chung về cái quyền riêng tư của mình trên môi trường số, bảo vệ chính cái quyền riêng tư của mình trên môi trường số, đồng thời là tham gia một cách tích cực hơn nữa vào cái môi trường số. Thì đây là một cái dòng chảy nó không thể đảo ngược rồi, thì tất cả mọi người đều có một cái phần của mình ở trong đó. Thế và chúng ta cũng biết rằng là có rất là nhiều những nỗ lực hiện nay của chính phủ, của các cấp chính quyền cũng như là từ phía người dân là mong muốn rằng cái việc bảo vệ cái dữ liệu cá nhân là sẽ được cải thiện. Và tôi hy vọng rằng là những cái bài tập như chúng tôi đang làm hiện nay, rà soát lại cái việc tuân thủ trước nhất là từ phía các cơ quan công quyền đối với cái việc bảo vệ dữ liệu cá nhân của người dân trên cái môi trường mà mình tạo ra trước nhất đã, đúng không ạ? Sau đó thì cũng giống như là đại biểu từ Thừa Thiên Huế đã chia sẻ, như vậy chúng ta sẽ dần dần từng bước xây dựng được cái niềm tin của người dùng đối với cái hệ thống dịch vụ công trực tuyến hay là cổng dịch vụ cổng tương tác với chính quyền.
In any of the platforms interfaces that they use to interact with the governments. I'd like to share with Ms. Chung that yes, we looked at the profiles of the users of these platforms for the e-service portals and e-government portals. We do such a survey. We look at the demographic breakdown. And as Patrick mentioned, in the first 2 years, 2020, 2021, only 3.5% of citizens used e-portals or e-service portals, and less than 1.5% of citizens did have interactions on these e-service portals, and this was very low. And for the further demographic breakdown, we see that the use is more inclined more towards the public servants, public officers, or people in the public sector, but not so much by ordinary citizens. So that is the figures that we have. So it seems that the use of citizens the use of the public service portals and the e-government portals by citizens are still very low. So that is one of the questions that we'll need to answer, how to engage people to use these e-government portals, e-public service portals more is one of the key themes of the public administrative reform. And this is what we will be doing further in the coming time. And we hope to see the transformation of governments in terms of protecting personal data and in terms of increasing their interactions with citizens and enhancing citizens' users' experience and confidence on their system. We have 15 minutes left for any pending questions from the audience, both online and on site. I would like to give the floor to the participants in the room. One question each. So we open the floor to the participants in the room and also 40 participants virtually. Yes, I think that this is a very good, very interesting research. And as mentioned and discussed by previous speakers, it gives us some new insights. I would like to suggest to the research team that the personal data here needs to be protected. All agree. However, in our view, personal data is unprotectable. And this is a general view by many people, right? I think that the best we could do is just to try to save these providers the personal data less damaged, less affected, and mitigate or minimize their loss. Because personal data is provided by many people and also many stakeholders want to be in possession of such data. Public sector, private sector, individuals. And in the future, we can see many other things. So when it comes to protection of personal data, I think that this review is still at a very preliminary level of invoking our thoughts. I wonder if you have considered, if you have considered making any advice or recommendations to the circular on the draft decree on personal data protection. Have you been closely watching their move? Because we have been working on data note prevention. So, you know, data are now being transformed and being transferred and circulated, and our personal data is being moved everywhere. So it is not located in one place, and then it is very hard to protect such data from being lost or from being damaged. So I encourage you to expand the scope of your research and please make very specific and practical recommendations. So make it like a research team, the research project registered under the Ministry of Science and Technology. Yep, thank you very much. So from the research team perspective, I just want to respond that our thinking about protection here is not just putting up all the barriers or fences or safeguards, but we agree with Mr. Khang that protection here needs to be in a balance with promotion and encouragement. So protection that we refer to here means, building the controls and the mechanisms to prevent from abuse of data, but not to ban everything altogether. And learning from the EU experience of, distinction between data collectors, processors, and users, for example, would give us more chance to protect data rather than the misleading understanding of, putting bans all together. Thank you very much for your suggestions for the directions or approach for the research team to make it more practical. And that is also the purpose of the discussion today. And we highly appreciate the inputs from you and the experience shared by Mr. Dương Anh, because we think that those are the useful experience from the local governments. So we want to put together this experience. We don't need to reinvent things. We just need to learn from what Thừa Thiên Huế has done, and it would be meaningful enough. Thank you. Yes, I just want to add one more point. Yes, how the IDs, digital ID, the sovereign ID system in Vietnam is being used. So this is a new system, and we have the 12 number ID, 12 character ID number for citizens, which integrates the information on the address, permanent address, and social insurance, and driving license information, etc. So, for the public servants, they have to adhere to the requirements of protecting personal data. So if they are authorized to have access to data protection, they are obliged to keep this data confidential. And also we have the law on access to information with the classification of information to be kept by persons and to be kept by public agencies and provided by public agencies. However, there is a gap that the definition on personal data is not comprehensive, is not complete. So the personal data is understood as date of birth, address, right? And phone number. However, it may also include bank account information, bank account number, vehicles license, vehicles number, right? Regarding the proposal, the question of whether a dedicated officer should be in charge, I agree with the colleague from Thừa Thiên Huế. This needs to be a feature in the system. One person may not cover everything, but then there needs to be a focal point for providing information. So the boss, the manager of the agency would appoint a person to be in charge of data provision. And the person that has access to data to be the data provider should also be obliged to our principles, to the rules. And I agree that training for skills, training to enhance capacity of our people to use the breaks that we design for the system is the way to go. Okay, so we don't need one more person, but we need improved roles and job description. So, you know, we cannot not have more people in government agencies because it's against the general direction of public administrative reform. Yes. So we need to be flexible, we need to be practical, and we need to work appropriately. Yes, I just want to make one more point. I think that various views and a diverse range of views and points is very important. So if we can educate, work more on the education, if we can work more on awareness raising, like the terms and conditions or the notes or the instructions, the reminders to users of the public service or platforms, portals, and then we can disseminate this information to citizens, to users. That would be a very proactive and practical intervention. Sometimes minor things can change a lot, but otherwise, if we just try to focus on a high level legislation making, but we don't raise awareness and we don't enhance capacity, the gaps will still be there. Okay, so practical recommendations sometimes matter more than the high level general recommendation. Yes, I agree. So this is one of the outputs, future outputs for us to be followed, to follow. And of course, I agree that if we can have the do's and don'ts to disseminate to the people, to educate the people, like in Hue and Tiền Giang have already done, that would be good practices. So this is not something new. This is not something that thinking out of the box or breaking the fence, right? I think that the 17 criteria of evaluation are all based on existing regulations. So this is like a, yeah, I agree, like a reminder and additional education and awareness raising that we need to work more on that front. One more question, if any, because we have 7 minutes left. And Mr. Hoa will have to leave this meeting right now. Thank you, Mr. Hoa, for spending time with us. Thank you. I am Hoa. I'm lecturer at the University of Social and Humanitarian Sciences. And we have a new major of information management. And I got highly interested in the topic of the discussion today. And I have one question to the research team. When we look at the color codes on the backdrop, I could see that there is a summary, I mean, an executive summary of the report. And I asked when I could receive the full report. And the response is that after this event, before receiving the full event, the full report, I wonder if the full report includes this. Because from the presentation by Mr. Dong and Ms. Ling, I see that the report mainly reflects the current situation of use and interactions on the e-service portals and e-government portals and government apps. And it seems that the researchers mean to say that if this situation goes on, there will be gaps, there will be good loopholes, there will be risks and etc. Losses or damages. Has there been any actual case of damage done, of incidents happened? Because Mr. Dương and Mr. Khánh in their remarks also said that these operations on the platforms are all based on the existing regulations. And Mr. Dương and Mr. Khánh also said that maybe people do not care so much about, reading the terms and conditions when they check the tick box. So is it right that what you say here is just to give a warning, or has there been already breaches? Have there been already incidents violations and damages done? Can you give us the example? Yeah, quickly responding to the methodology, and then Ms. Ling will talk about practice. The limits of review, the scope of review. We only focus on the policies, on the privacy policies, because we deem these privacy policies the place where commitments between the government agencies and citizens are made, right? So this is their commitments, government's commitments to citizens. And these commitments are derived from legal regulations and requirements. And I believe that we believe that the privacy policies here should be the demonstrations of the legal requirements on privacy protection, personal data protection. So we don't have the ambition of cover a broader range. That's why, as Ms. Ling said, it is very limited. The tip of the iceberg only. So we only review on what is visible, what can be seen, and focusing on the regulations and processes. But we don't look at the risks or the phenomenon that can happen. We just see how the government agencies have been complying with the existing regulations on protecting personal data. So it has not come that far as you asked. Ms. Ling can share with you some incidents that we have observed. Yep. Thank you, Mr. Hua's question. To follow on Mr. Dong's comment, even though our research only focused on the tip of the iceberg, part of the tip of the iceberg, but it is very important because the underneath, the part underneath water, the government agencies have the internal regulations and processes on data protection already. But why do we focus on this tip of the iceberg? Because internal things is one thing. However, at least we need to see the commitment between local governments and citizens. So we focus on the rights to privacy of citizens and citizens' right to their own data. So we want to have sample guidelines on privacy policies, because the privacy policies, when goes with the e-contract, I mean, terms and conditions, right? It would form an e-contract between the public government and citizen. So in the privacy policy, this is where the government would tell the citizen that these are their rights and these are the mechanisms that will be implemented to ensure these rights. And this is the contact point that you can get, you can call or we can get to when you have problems. So we care a lot about these privacy policies for that reason. The next point you ask, any incidents, right? Any problems? Yes, they have. Because as Mr. Dong mentioned, under the IBM survey, leakage or loss of data have been looked at so far, mainly from the private sector's perspective. However, the leakage of data from the public sector has become an emerging, has become more serious. And 80% of loss economic leakage comes from the public sector, has grown by 80%. And just a couple of months ago, there was an event organized giving statistics that every week about 100 gigabytes of data was lost or leaked, including data registered from the public data platforms or database. In the report, you will see more details on the specific situations on how data protection breaches happened and caused damages. Because even on the public domain, there are many places where personal data can be leaked, but people may not have paid attention to. For example, FAQs, for example. And in Đồng Tháp in 2020, there was an incident that the person's information was put on the public domain, was disclosed. And then the chairman of the Đồng Tháp provincial committee requested VNPT Đồng Nai and the DIC to enhance their protection on their system in order to make sure that personal data is no longer disclosed improperly. Yes, in Hậu Giang, for example, you can see a very clear commitment by the provincial committee that if personal data is lost or is disclosed improperly, then we will make it public, we will inform you, and we will take measures to react or to address. And I hope that you can use the data that we collected for further analysis. So we have the raw data, and you can use the data for your own exploratory purposes. So the data will be published on IPS website, and you can refer to that. Thank you. Yeah, one final question from the room, and then we'll close the discussion. Yeah, so just one last question. Thank you. Yeah, just a minor question. When you said that Hanoi People's Committee mentioned that they would sell the personal information to promote digital economy, where did you get that from? Yeah, the statement was made by the former chairman of the Hanoi People's Committee, and it is publicly available. You can find many articles and many mass media outlets that he said that the personal data would be used to promote digital data. I just did a search, but I didn't find it. Well, I think that the word sell here is very sensitive. So we need to really understand the implications. What data is he referring to? So because selling personal data is, of course, is not allowed. However, if you know, selling raw data on demographic, I mean the public data, not personal data, it would be useful for promoting digital economy. So it seems to me that what he referred to, what he meant, really meant, is the statistical data, but not personal data. Yeah, the reason I asked was because Mr. Huynh specific referred personal data, selling personal data, and that would be dangerous because it would be really against the law, and it is unacceptable. That's why it gave me concern. That's why I had to clarify this. If Hanoi says that they would sell this personal data, then it would be a crime, right? It's unacceptable. Yeah, that is in their intention. That is when they had a discussion on, you know, developing e-government. They also thought about commercialization of data collected from digital platforms. So the idea is actually has been made fairly clear in various discussions. They said that they would consider, they have not, right? But perhaps after they were making that suggestion, it also got discussed. Yes. So we can share with you the sources. We plan to include that slide. However, due to constraints of time, we did not include the slide to give you the evidence, the source of information. The former chairman of Hanoi People's Committee made that statement, suggestion, initiative that we may exploit the residential data. He's not so specific about what information, what data. However, data protection and data classification is very important. Yes, for any data sharing services later on. That's why we really have a concern about this. This idea is a further, I think that fortunately we had the break put on this idea. Not so good idea, right? But I think that it is also a good prompt, a good reminder to local governments to take the real caution when to stop them from going too far when discussing the initiatives for digital economy or commercialization of data. And thank you very much for your listening. And before we wrap up, I will give back to Mr. Dong to make the closing remarks. Yes, thank you. Thank you all for attending this panel discussion. Thank you, Mr. Dương Anh and Mr. Tứ from Ho Chi Minh City and Huế. Thank you all for your attendance. Ladies and gentlemen, we are 8 minutes behind schedule. And on behalf of the research team and the organizers, we would like to thank you very much for spending your time with us at the discussion today. After this discussion, we have the work to follow with following up with the recommendations and comments that you made today, and we'll incorporate them into our future work and improve our report to share with you. And one more thing, we hope that Mr. Khang's suggestions or advice here, for example, documentation of the good practices, to turn them into the handbook of do's and don'ts, we'll do it. And then we'll disseminate broadly to all relevant stakeholders, particularly the Department of Information and Communication, which are involved in this task. And at the IPS, we stand highly committed to continue our work with personal data protection in the upcoming period, including personal data from the private sector and public sector. And we hope that UNDP, Mr. Khang, and everyone will continue to support us. Once again, thank you for your time and your contribution. We'd like to call it a day. Thank you. And goodbye. Wish you all good health and see you in the future.